This morning, we'll be taking a look at the P&ID. The news on Monday that Nigeria won a case in London was greeted with jubilation by some members of the public, that the country has saved itself from paying over $11 billion. By the current exchange rate, we'll be talking about nearly 11 or over 11 trillion naira if you just do 1 to 1,000. To the British Virgin Island-based company, Process and Industrial Development, P&D Limited. However, this morning, Daybreak will be analyzing the judgment and lessons for Nigeria. And to help us do that, we have in the studio a legal practitioner, Barrister Mutiu Akinsanya. You're welcome to the studio once again.
Good morning.
It's a pleasure to have you back in the studio. The last time I understand you were running to go and catch a case.
Exactly.
And we hope it went well.
It went well.
Yes. All right. The P&ID.
Yes.
That judgment came in on Monday, and it's like a country that has been yearning for one good news from anywhere, whatever it is, just to take our mind momentarily away from all of the events that have been taking place in the country, whether it is inflation or exchange rate jumping over the roof and all of that. And this judgment came in, and it's been a case that we have been on for quite a while, with the judge delivering a judgment via mail. It's the first time I've seen that procedure, by the way. Relieving Nigeria from what would have been a major international embarrassment, What do you make of that judgment when you heard it?
Oh, thank you very much. For me, I think it's a huge success for Nigerians generally. And like you said, it has saved us of a huge embarrassment. Economic embarrassment, political embarrassment, and social embarrassment. That money is huge, and it was a mistake of a few corrupt public officers and civil servants that will have put all of us in a mess.
You call it a mistake. Is that the word? Or it was calculated, deliberately calculated to rip this country off?
Yes, from even what the judge who delivered the judgment said, it was clear it was a case of corruption by few Nigerians who had no interest of the country at heart. They were ready to sell the country off for a paltry sum that will go into their pockets. And I think it's really bad, but thank God Nigeria won the case, and we're not going to pay that arbitration award. That's more than the budget of a country for a whole year.
Absolutely.
But Barrister Akinsanya, speaking of thank God, for how long will Nigeria keep, relying on God's miracle, falling into traps like this? How is Nigeria supposed to handle any situation like this, whereby foreign investors come in and they want to do business with Nigeria? How are they supposed to follow the due diligence in order not to find yourself in this kind of situation again?
Okay, so in this particular case, you will find that P&ID itself perhaps understood the kind of environment they were coming into, and they were themselves complicit. They were complicit in the sense that they paid money to individuals, perhaps to facilitate that contract for themselves. And if you look at the content of the contract itself, it was a good thing that would have happened to Nigeria. Building of gas processing facilities that will have helped to increase, to make good the case of electricity that we have in Nigeria. But what the court did find was that the whole process that led to the award of that contract was not a good one. And the court also even gave narrations of instances where P&ID had even done several contracts in Nigeria, contracts for the police, contracts for the Nigerian army, and so on and so forth. And in all of those instances, they were able to point to individuals who collected money in dollars from P&ID. So I honestly really think that the entire process was a bad one. It was a situation where you find Nigerians who ought to be patriotic, who ought to protect the interests of the country, were not ready to do that. what they were ready to do was to get money for themselves and to get advantage for themselves, and then to sell the country off to investors who were ready to make so much money at the expense of the entire country. And it was also because of the entire processes leading to that. That was why it didn't work. So at the end of the day, it was a waste of time, it was a waste of resources, it was a waste of energy, because the contract itself till date has not been implemented.
Okay, just to help our viewers at home understand exactly what happened.
Yeah.
Because at some point, the Nigerian government was negotiating with P&ID for an out-of-court settlement.
Yeah.
To the extent that we agreed to even part ways with about $850 million.
Yeah.
It was the failure of the government to follow through with that out-of-court settlement that saw the P&ID return to the court in London. What exactly, just to help our viewers understand, can you walk us through that transaction dynamics?
Okay, so sometimes in 2010, the Nigerian government, represented by some public officers, entered into an agreement with P&ID to construct some gas facilities to enable the country to be able to power its electricity using gas. And then between 2010 and 2013, nothing happened. And then P&ID came up and said, we had an agreement, and the Nigerian government has not played its own role in that particular agreement, and that has caused us so much damages. And in that agreement, there's also a clause, it's what we call an arbitration clause, that says before you go to court, you will have to submit yourself to a tribunal, an arbitral tribunal, that will have to look into the issues and give an award if any will come up. So they had to then submit themselves to a tribunal, arbitration tribunal, which sat then in London. And Nigeria was to nominate one arbitrator, P&ID was to get one arbitrator, and then there was also an independent arbitrator. Unfortunately, at the end of the whole arbitral proceedings, two of the arbitrators held that Nigeria was liable to pay about $6.6 billion. And then Bayo Ojo, senior advocate of Nigeria, who was also the representative of Nigeria on that panel, was the only one who disagreed. But you know, it was then 2-1. So basically, the majority decision of the arbitration panel was that Nigeria was liable to pay to P&ID about $6.6 billion, because Nigeria did not play its own part in the contract agreement that was entered into in 2010. And then so it was back and forth. But after a long time, during the last administration, the government decided to challenge it in court. And that was what led to filing of this particular case before the English High Court. And then when the court looked at all of the circumstances, because if you look at the judgment spanning over 100 pages.
That's right.
Yes, the court looked at all of the circumstances, the role played by public servants and civil servants in Nigeria. In fact, the court even mentioned names. That's right. Some, unfortunately, are late now. The court mentioned all of their names and the role they played. The court was also able to find instances where some of those individuals also were paid monies in dollars by P&ID. And the court found that perhaps it was because those individuals were receiving those huge, humongous sum of monies from P&ID. So it was more about their individual interests. And they were ready to sell the country off for those little monies they were getting. So at the end of the whole proceedings before the High Court, the court found that that contract itself was obtained by fraud. And the entire process leading to that contract and even leading to the award was entirely against public policy. Public policy for Nigerians. In fact, at the end notes in the judgment, the court even mentioned that few individuals in Nigeria who were very corrupt decided to use that to want to punish majority of Nigerians because of the corrupt their corrupt nature. So basically, in summary, that was what happened from 2010 to the day the judgment was delivered.
Barrister Akinsanya, from everything that has happened, there is a lot of lessons Nigeria could pick from this particular case and learn from. So as citizens, because we're quick to blame the government and say government is doing this, meanwhile, we make the government, we're part of the people. So as citizens, what do we need to do in order to curb this corruption, the prevalence of corruption in Nigeria, where in every contract someone applies for, you have to pay some percentage to some government officials who are corrupt. And at the end of the day, they don't even see through to see the execution of that contract.
Yes, I think this is a daily thing we deal with in Nigeria, unfortunately. And unfortunately, a contract of this magnitude that led to this whole case in this situation was a contract that was being entered into by the whole country. But of course, it was few individuals who were involved on behalf of all of us. I think one important thing that we must all learn from this point, and I think this lesson is for the government particularly, is that all agreements that have been entered into by the country must be properly vetted by those who should vet the agreements. And you know that the legal officer of the whole country is the Attorney General of the Federation, the Minister of Justice. If you look at the whole of this P&ID case, you will find that the Attorney General did not really have any inputs when it comes to the drafting of that agreement. Those perhaps who drafted that agreement were individuals who should not have negotiated that agreement on behalf of the country. Yeah, so the Attorney General must at every point in time be on top of his job to ensure that when you have agreements of this magnitude, he's able to look at them critically and ensure that the interest of the country is protected. Unfortunately, it's not only this agreement. You have several other agreements. Some are even in court that I would not want to talk about on air, where you will see that when those agreements were drafted, because the individuals who were representing the country were complicit, perhaps because of the monies that would go into their pockets, they just gave out the country. And it is very difficult to discover them immediately. It may take years to then come to find out. Like this P&ID, it took us a very long time before we found out what was exactly happening. Unfortunately, at the point that we found out, even the Minister of Petroleum at that time was late. The late Rilwani Lukman was already late. So he was not even there to even speak what role he played.
But just so to understand this process you're explaining, because I am just trying to minimize that whole process flow to something obtainable, let's say in a private organization like ours. If you have a contract of that size, that threshold, one would have thought that it would have also required a council approval. And at the level of a council approval, the Attorney General's opinion would have been contained in that document. How do we process such huge transaction of that size and bill without getting a council approval, when even local contracts in Nigeria of the threshold of about R1 billion would require council approval? What exactly happened? Was this smuggled? Was this signed off without council knowledge or what?
Yes, shockingly, I've looked at the whole judgment and I didn't see anywhere where maybe the Federal Executive Council gave an approval. And that is why you will see that the names that featured, one very prominent name was Grace Tiaga, who I also know had been arraigned before the FCC High Court. I think the case is still ongoing. Her name featured severally. In fact, there were exchange of emails between her and the representatives of P&ID. Yes. So, but that also shows you that we have a huge gap that we need to cover, and that our government and public servants needs to really be very sincere. Yes, a contract of that magnitude ought to get to the Federal Executive Council. The Attorney General ought to be aware. The president of the country at that time ought to be aware.
The public procurement as well.
Yes, but you will recall that around 2010, if you remember, that was when Yaradua was critically ill. And perhaps maybe that was one of the reasons why they were able to get away with that because of the president's illness at that time. Maybe we still get to still know a lot of things that happened, but I think that was one gap that going forward, all of us must pay critical attention, and the government must also pay critical attention to ensure that contracts of this magnitude are not managed by few individuals who may be compromised, but it has to go through all of the procedures, even up to the Federal Executive Council, to be able to look at it critically and say, oh, this is approved. We have looked at all of the clauses. No clauses are against the interest of Nigeria and Nigerians, and then it's approved.
Just a tie back to this before she comes on board. So, in making laws in Nigeria, basically, we get to a point where we hold public hearings, where we take expert opinions, subject matter experts come in and say, I've looked at all you're trying to do, but there are lacunas in this area, or we can fare better in this sense. Have we not come to a point in this country where documents like this should also, the draft of this kind of agreement should also be exposed for some kind of public opinion, maybe for some days, so that people can offer perspective on those contracts? And I say that because we have seen this kind of contracts everywhere. BASA agreements, for instance, we have BASA agreements with countries who will not allow us land in their prime airports. They will take us to somewhere in the interior, but they get 20, 30 slots to land in all of our prime locations, and we are unable to do anything because we have signed off on BASA agreement that has, from day one, put us in a negative position. But one would have thought that if you had exposed these things to Nigerians, players in that industry would have said, you are selling us out because of the nature of this agreement, or it's basically skewed to the people you are signing with. Should we begin to think of this kind of exposure?
Yes, I think even the court in the judgment, the Court of England in that judgment, stated that the whole contract was one-sided. And that perhaps what happened was that those representing Nigeria were not beyond the fact that they were compromised and that they were corrupt, that perhaps they were not also experts who should represent the country. So P&ID was in a vantage position and Nigeria was in a disadvantaged position because of the caliber of the people who were representing Nigeria. So basically, you know, some of these agreements, they have confidential clauses. And they're not agreements that you can just throw into the public space and say we want all Nigerians to give their inputs. But what becomes important at every point in time that Nigeria, Federal Republic of Nigeria, is entering into any agreement is that we must get experts to always look at that agreement. If you're entering into a gas pipeline agreement, for instance, you must get experts in that field to be able to look at the clauses and say, oh, this is okay, this is not okay. You must get lawyers who are professionals in that area to say, oh, this clause I think is fine, this clause, oh, is not fine. For instance, you will see that in the judgment of the court, for instance, the court found that Grace Tiaga, at that point in time, was the one who even agreed to some terms. For instance, the place of arbitration under the arbitration clause ought to be Nigeria in the first draft. But when they said, no, we want it to be in London, she just gave in to it. So ordinarily, lawyers who are in practice or professionals will have been able to look at it and say, oh, this is best for Nigeria, or this is not good for Nigeria. They will be able to look at it critically and ensure that they have a balanced agreement. And unfortunately, perhaps if the agreement was balanced, maybe P&ID will have been able to even get the whole award, because looking at what the court didn't even go into the merits of the document. What the court just found was that the process leading to the award of that contract and even the arbitral award was marked by corruption, was against public policy. So perhaps if the court had even looked at the role Nigeria had played, that, oh, you didn't play your own part. If the court wanted to look at it on merit-based, perhaps it would have gone the other way.
So it was a case of something standing on nothing.
Exactly.
Indeed.
Yes, yes.
All right, so one of the agenda of the president, Bola Ahmed Tinubu, is to bring investors, the foreign investors, and we saw him in Onga talking about, you know, if foreign investors want to come, then Nigeria is welcome, as long as, of course, it is mutual. So do you think this case, because it is public, do you think that it would affect, the foreign investors coming into Nigeria negatively?
I don't think it would. If foreign investors are coming here and they're serious to do business, if they decide to be corrupt, then they may have problems like this. But if they come into Nigeria with the serious mind of doing business, of getting all of the approvals, right? And of doing everything they should do, because they're coming as investors. If anybody asks them for bribe or to be compromised, and they say, see, we're here for business. And I think that's also one assurance that the president also needs to give all of these investors. If they have that promise by the president that, see, I'm going to protect you and I will ensure that nobody takes advantage of you. So if you're coming here, come here to do business and we'll give you the right platform. I think if they get that assurance from the Nigerian government and they see that from public officers and from civil servants, when they need to get approvals, they get them without having to pay through their nose, without having to pay any individual. What they will have to pay are the official fees, and they get all of that. I can assure you they will come here and they will do their jobs. You will have found that even in the course of our history in Nigeria, you will see so many abandoned projects. Roads are abandoned, public buildings are abandoned, hospitals are abandoned, schools are abandoned. And if you go to find out one of the reasons why you have all of those projects being abandoned, you will find that maybe some of the contractors who are giving those jobs, they have spent more than 50% of the money they ought to use to work, they've given to private individuals. And those individuals who also ought to also go to check will then relax because they also know they're complicit. But if we have a country where investors, whether local investors or foreign investors, have that promise from the government that what we will expect from you is show us that you can do this and we'll allow you to do it, I think we will be able to move very fast in infrastructural developments in Nigeria, and our country will become a very good one for all of us, not just for few individuals.
So, Barrister, when I was getting that, I mean, in thinking through all of this, one of the things that kept pricking my mind was, with the way we have managed this particular transaction, is it possible that we are sitting on a mine, as it is right now? Is it time for the Attorney General to sort of set up some kind of committee to begin to review some of those contractual terms we have entered and begin to identify those landmines so that we can manage the process rather than fall back, have another P&ID case come up? And I'm saying this in the light of some of the things that happened in the Buhari administration. You recall the Ajakuta case, where the government had to settle for about 496 million because of those failed contractual. We saw that with the Steve Dovering Services versus Shell. We also saw that with Mambila project, where the federal government also settled for about $400 million. We seem to be losing so much money to some of these fraudulent contracts. Is it time we take a holistic look at some of these major contracts we are taking, and would there be any kind of room to renegotiate the terms at this point?
Yes, I'm sure from the last administration, particularly when this P&ID case came into the public, I'm sure the last Attorney General already started something like this. And I'm sure our present Attorney General, who we all know very well is a man of integrity, will also not take this very lightly. I'm sure that they will have taken their time to look at all past agreements to really check and see and ensure that no clause is against the interests of Nigeria. And I'm sure going forward, I do not think, honestly, that this kind of mistakes will be repeated. Because as a country, we must learn from the past. And if in the next few years we still make this kind of mistake, then it will be very terrible. But what becomes also important at this point is that those who may have been complicit, the government must take those cases up and ensure that those who need to be prosecuted are prosecuted. Because that's the only way the government can send serious message out there that we're serious about these things. And any public officer or any civil servant who gets himself involved and puts the interest of the country in in jeopardy like this, that will go after them. So for all of those who have been complicit, I think the government must follow up with their cases up to the end. And for those who should be sent to prison, they should be sent to prison. For those who will not be found guilty, yes, the court will have to do its job. But we must not take these issues lightly and just sweep it under the carpet and feel, oh, since we have gotten this judgment, let everything go. Those who were complicit, who are still alive, must be punished.
Interesting. When we talk about punishment, I wish the government had signaled this in some of his preliminary statements. Basically, the statement we saw from the Villa was just celebrating the fact that we won. The statement from the Attorney General basically talked about the embarrassment it has saved us. Should the Economic and Financial Crimes Commission, for instance, or the Independent Corrupt Practices Commission be waiting for some kind of presidential order for them to begin to go after these cases, as you have said? Is this something they're supposed to move swiftly into action on their own without any prompting?
I don't think they need any presidential order. The EFCC Act, for instance, empowers the EFCC to make investigations in cases like this, and anybody who is found complicit can be charged. But of course, Grace Tiaga's matter is still before the FCC High Court, and I know the EFCC is following very closely on that matter. But you will have also seen that in her own case, because she had retired long ago before they found that she was complicit, right? And at this point, even if you see her in court, you know she's very old already. And the case has suffered several adjournments because even of her health situation. So one other great lesson is that we must not wait for years before we discover things like this. Right from 2013, when this matter was before arbitration, I'm sure we already know people who were involved. But you see, it took us a very long time. I think she was charged sometimes in 2018, about 5 years even after we got to know of all of the roles they played. So what's important is that we must always act in time. We must act timeously. If her case had been in court maybe at around 2013, we would have gone far. And we wouldn't have waited until she's now an old woman. I'm sure she should be above 70 now. That's right. And then we're dragging her in and out of court. And we're unable to really make any headway.
Speaking on that, the delay thing, as a legal practitioner, we spoke, I think, yesterday about the situation of justice being delayed, where they just drag the whole thing. So this P&ID case also showed that kind of situation where there was a lot of, the Jonathan administration quick to negotiate, and then there was the prolonging of Yar'Adua, Buhari coming and saying, no, I don't want to go that way. So this could have gone bad if P&ID had won the case, because we saw how the money kept escalating and increasing to a particular amount. So what do you think the Nigerian government should do in terms of making sure they push, they find out, discover cases and push, to get that case done and dusted with?
Okay, so if you see all of the proceedings regarding P&ID, none was really here in Nigeria. The arbitration was done in London, and then when it also came to setting aside the arbitration, it was also the High Court in England that also had jurisdiction to set it aside. But arbitration matters are not done in the public. So usually if you have a contract agreement between two individuals, commercial agreements really, there's usually an arbitration clause to say, see, if we have any misunderstanding, we'll have to submit ourselves to an arbitration panel or to an arbitral panel to look at the issues. And what arbitration panels give is not a judgment, they give an award. So it was out of that arbitration proceedings that you got that award of about 6.6 billion. Yes. But so after all of that, P&ID was then trying to get its money from the Nigerian government. You understand? So there were advice, let's settle with them, let's see how much we can give them. Until the last Attorney General looked at it and said, we're going to challenge this. And then they went to court. So honestly, I do not think it took too long a time, because looking at the nature of that matter, I think it went to court sometimes in 2017 or 2018, and we have the judgment after about 5 years. If you look at the work that the judge did, And if you look at also the kind of witnesses that were called that needed to come and give their testimony, you will find that for a matter of this nature, maybe 5 years was not too much. And that's why I say also thank God that it was in England. If it was in Nigeria, maybe the story would have been different. Maybe we will still be in court, still dragging back and forth.
That's true.
You understand? And perhaps it's also because some of these foreign investors know the nature of our justice system here. That's why they will never want to have any arbitral sitting here, because they know that when it comes to enforcement or setting aside, it will have to be the courts here that will have the jurisdiction. So the lesson here is that our judiciary must also be up and doing. We must give the entire world a very good image that if you come before our courts, your matters will be heard speedily and you will get justice. I think if that message is really sent to the entire world, investors who are coming here will not insist that they want their any arbitration arising to be in any country. They will say we want it to be here because they know they have confidence in the judicial system and they have confidence in our judges.
Indeed. All right, we are beginning to see similar things even back home, and not at the scale of the P&ID. Yesterday, I think it was from Benue that the state chief judge was saying that they met a consent judgment to the tune of over 15 billion. Remember, Wike was saying for the FCT administration, over 800 million consent judgments were obtained. Why is it beginning to look like these things are just designed to end like this so that we extort money from government?
I wouldn't know. You know, you have to look at each case and the peculiarity of the facts in each case. Settlement, of course, is encouraged in every jurisdiction, including our jurisdiction. So if you have parties who have issues and they bring it before court, it's good that they settle these matters so they can all go back to business. And for every investor, like I said the last time, no investor wants to be in court and be in court for 2-3 years. Any good businessman, if he has issues with his partner, with any other person, wants that issue to be sorted out quickly. So, and one of the reasons why people will say, oh, let's quickly settle and go back to business is because they know that if they remain in court, they may stay for the next 10 years and it will affect both parties, you know. But if you are sure that if you file a matter in court today, in less than a year, you will get judgment and the matter will be done with, I think a lot of people will have so much confidence in the judicial system. This P&ID case is not a case involving an individual. It is a case involving the largest black nation in the world and a very big company. And then it took the High Court of England just how many years? If it's in Nigeria, with our current situation, you're sure it will take us much longer than it took them.
Interesting. All right. I hope we have been able to delve.
And lastly, can I just also say this? Even the judges also commended the lawyers who represented both parties because they also went into the substance of the matter. They didn't deal with technicalities. You understand? So the judges themselves commended the lawyers. And I think that's also one great lesson for us here as lawyers, that when matters of this magnitude come before the courts, we must also help the courts to deal with these matters speedily.
And help set precedents for the practice. Thank you very much, Barrister Mutiu Akinsanya, a legal practitioner who has helped us understand some of the judgment beyond just the celebration that we see out there about not falling into another trap. We are practically scamping for breath when it comes to foreign exchange right now. Every piece that we can get, it would be useful for our national courts to think that some kind of judgment would have gotten us to pay 11 billion at a time where we are struggling to fix 4 refineries for under $2 billion. That would have been catastrophic. I want to thank you very much for the insights that you bring to this conversation.